Commissioner Whitson, and the pledge is led by Commissioner Snyder.
Our mighty Heavenly Father, we come to you on this day recognizing your power and your strength, and that all creation is yours. We, as your creation, Father, praise you and thank you for giving us another day here. And we thank you for the opportunity to come together to care for our community. Help us to make good decisions with your wisdom as we recognize that you are our first priority, and our love for you and then our neighbor as ourselves. And upon those two things hang all the laws of the prophets. In Christ's name we pray. Amen.
And the women have pledged their flag. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, Texas, one state under God, one and indivisible.
Commissioners, item 3 is our consent agenda. All items listed on the consent agenda are considered routine, not requiring a separate discussion or vote, may be considered on a single motion. However, at the request of any commissioner, any item may be removed from the consent agenda and discussed and voted on separately. There are 3 items on the consent agenda. Consider approval of minutes from June 22nd of the Commissioners Court, our personnel and budget amendments, claims, which are accounts payable, payroll, restitution, and jewel pay. Happy to entertain any questions or a motion on the consent agenda. Motion made by Commissioner Driver. I'll second. Seconded by Commissioner Snyder. Any further discussion or questions on the consent agenda? If not, all in favor say aye. Aye. All opposed, same sign. Motion carries. Thank you. Item 4 is to conduct a public hearing to consider tax abatement agreement submitted by Robert W. Hawksworth on behalf of First National Bank for property addressed at 2201 Tremere Road, Killeen, Texas, and located in the Killeen I-14 Tremere Road Reinvestment Zone. The tax abatement request is in consideration of a new 5-story, 47,653 square foot facility with furnishings, equipment, fixtures, and associated architecture and engineering expenses at a cost of $14,695,261. Court, we have discussed this and seen this before, just in terms of opening comments. The tax abatement agreement notice was given in this meeting. Notice was also sent with a copy of the tax abatement agreement to the taxing entities, and those were Clearwater, Killeen ISD, Bell County Tax Appraisal District, City of Killeen, all received notice of the proposed tax abatement agreement. The City of Killeen granted tax abatement on the project on May 4th, 2020. And again, this item is returning to you for consideration and action today after the public hearing. All right, with that, any questions before opening the public hearing? All right, at this time, I will open the public hearing. And if you wish to make any comments on the proposed tax abatement agreement with the First National Bank of Texas, please come to the podium. And state your name and address for the record, please.
Yes, sir. My name is Scott Airy from Harper Heights. Okay, good. Thank you. Judge, Commissioners, thanks for, first of all, thank you for acknowledging and making the 30-day notice requirement under law available. Sort of transparency of anything with taxes critically important, and I appreciate you setting this thing. I've reread the policy. I'm not here to speak for it or against it, but really just to bring up some issues that I think I'd like you all to consider in the future going forward. The policy that's here dated November 2019, quite comprehensive, but we all know it pretty much allows the Commissioner's Court really to give a tax abatement really for any investment or really anything it deems to improve the quality of the community. So here we are giving a tax abatement that in total will be over $1.2 million, a majority of that through Killeen. And what I'd all ask you to consider is, as you review this policy, consider, is it just going to be for the most well-to-do, or should we be doing something to encourage small business to be here? For if we can give a tax abatement for a bank that will provide no new jobs and is in a reinvestment zone that literally was created at the very same meeting at which Killeen gave the tax abatement, then shouldn't we be doing things, whether it's Seneca HVAC, who put a building up in FM 439, should it be for any of our small businesses to say, we really want to encourage and stay in here and we want to expand? If we're going to expand a bank with no new jobs, we could certainly, I think, do that for everybody else, and making this more available and more accessible it's a small business, I think will be an improvement to the community. But of course, as we do that, we have to realize that every time we give a tax abatement, we're creating a hole under that 3.5% constraint, and that tax burden gets filled by somebody else. So it's certainly a give and take on that thing. And generally, who pays that on the back end is residential taxpayers. We know that property value studies will generally indicate residential is at about 100% of appraised value, commercial properties at about 85%, and certainly that may correct in years going forward. But residential homeowners generally are paying the taxes. So every time we give a tax abatement, that burden gets shifted to somebody else. I know you have a task of trying to keep the best businesses here. I just ask that you, when you look at this policy, you see how do we make it more accessible for everybody? How do we make sure it doesn't become a burden to a smaller and smaller group of residential homeowners? Thank you.
Thank you, sir. Anyone else? If not, I will close the public hearing and happy to entertain the motion or questions or discussion on the tax abatement agreement.
I move to approve the tax abatement.
Motion made by Commissioner Driver.
Second.
Seconded by Commissioner Snyder. Any further discussion or questions? If not, all in favor say aye.
Aye.
All opposed, same sign. Motion carries. Thank you, Court. Item 5, consider the appointment of Dr. Luella Tate as Central County Services Board Member with a term beginning September 1, 2020. Court, I think you should have or got word that I'd received a request from Dr. Helmkamp of Central County Services asking that we confirm, or I'm sorry, that his board chair confirm Dr. Tate is interested in serving another term as a board member, and asked, we appoint this position or confirm this position for that board, and simply asking to approve Dr. Luella Tate as a Central County Services Board Member for the term beginning September 1, 2020. Happy to entertain any questions or comments that you might have. Or a motion.
Move to approve.
Motion made by Commissioner Whitson.
Second.
Seconded by Commissioner Driver. Any further questions on this item? If not, all in favor say aye.
Aye.
All opposed, same sign. Motion carries. Thank you, Court. Item 6 is consider approval of a resolution in support of the nomination of Commissioner Bobby Whitson for position on the Texas Water Development Board Regional Flood Planning Group. Court, you may have gotten a notice. I got a notice last week. Maybe the week before, yeah, Thursday, June 18th, soliciting nominations of individuals to serve on an initial regional flood planning group that has been created or is being created under the auspices of the Texas Water Development Board. There are nominations for individuals to serve as members of 15. There are going to be 15 inaugural regional flood planning groups across the state. It sounds very similar to the regional water planning groups in terms of structure and organization. And the board is going to consist of one individual from what they call 12 interest categories. Those categories include ag interest, industry, river authorities, cities, counties, water districts, flood districts, electric utilities, public water utility, environmental interest, and small businesses. And so Commissioner Whitson has indicated an interest in submitting his nomination for that board. And this is a resolution that would be in support of that nomination. Any questions on this one? If not, I'll entertain a motion.
So move to approve.
Motion made by Commissioner Driver.
Second.
Seconded by Commissioner Schuman. Any further discussion or questions? If not, all in favor say aye.
Aye.
All opposed, same sign.
Martin is abstaining.
And we'll mark Commissioner Whitson as abstaining. Motion carries.
Close.
It was close, though. All right. Item 7, consider authorizing county judge to execute a modification to the Centex Fire and Arson Task Force interlocal agreement between Bell County, Coryell County, Colleen, Harker Heights, Belton, Temple, and Copperas Cove. The fire marshal here, and I'll let him address this if need be, but my understanding is this is an interlocal agreement that we've had for some time, and there was a modification made to one of the, what I would call legal boilerplate provisions relating to claims against parties for losses, damage, personal injury, et cetera. I'll read that provision here, and again, there's been a slight modification to it, but I believe that's the only change to the agreement. Each party raise all claims against other parties hereto for compensation for any loss, damage, personal injury, or death occurring as a consequence of the performance of the agreement, except as expressly otherwise set forth herein, to the extent caused by gross negligence or intentional wrongdoing of an officer, employee, or agent of another party. No provision hereof will be construed as a waiver, relinquishment, or limitation upon any immunity or defense that would otherwise be available to a party, its officers, employees, or agents. All such rights and defenses expressly herein retained. That sounds like a lawyer wrote that. Basically what that's saying is that unless there's gross negligence involved, we're not responsible for, or the party's not responsible for that negligence, and each party is going to be responsible for their own actions under this interlocal agreement. Happy to entertain any questions or ask Fire Marshal to come forward and explain that any further, but that's the only modification that I saw in the proposed agreement from previous agreements. Mr. Malstad.
So that section that the judge just read through was added. I guess Temple sent that over a week or so ago for the judge's approval for us to be members. A couple of years ago, we got together amongst the county fire marshal's offices. Sorry, I can't see, I'm fogging up. Come up with a task force where it's more to benefit the smaller agencies, such as me being a one-man show. Belton has just one fire investigator. Harker Heights has one plus their fire marshal. So in the event that we had a large-scale fire investigation, we could call upon this task force to just get additional resources to either work the scene, conduct interviews, do follow-up, stuff like that. And it would give everybody jurisdiction amongst the county, regardless of your agency. That was originally signed by Judge Burroughs. I had brought it up a few months ago, and Shelley did some research of the minutes. However, the original agreement that was signed by Judge Burroughs, there were still some edits that were never addressed, I guess, but it was still signed. So this is just basically an update, renewal, I guess we could call it, with some changes that I believe Temple proposed, which are the ones that the judge covered. So.
What was the original date on that?
The one that Judge Burroughs signed was August 24th of.
Judge Miller from Coryell, he was signing, so Gatesville and Coppers Cove, they still.
Originally, it was just Coppers Cove, and because Coppers Cove was in Coryell County, they wanted their judge to sign off on it as well. It didn't extend any further west than just Coppers Cove. And the reason we included them is because they don't have a lot of investigators. The ones they do were very new. But I don't know if you're familiar with the West Side and East Side grass fire strike teams. Them and Fort Hood are part of that as well. So we tried to kind of keep it similar to that as far as who was participating.
Any other questions? Thank you, sir.
Thank you.
Motion on items. Commissioner Whitson.
Second.
Seconded by Commissioner Snyder. Any further questions or discussion? If not, all in favor say aye. Aye. All opposed, same sign. Motion carries. Item 8 is to consider authorizing county judge to execute a 36-month agreement with Ameriflex as the carrier for the flexible spending account for Bell County employees for contract beginning November 1, 2020. Court, we had a workshop on this last week. Went through the proposals that were received. I think we had 3 or 4 proposals in front of us. I would ask See Laura here. I don't know if Amy is prepared to answer any questions. She's shaking her head no. So if there are some questions, I'll try to entertain or try to address those and give Laura time to get down here. The agreement, again, creates a flexible spending account which allows for employees of the county to set aside pre-tax some of their income and use it for designated expenses as allowed by law. There's a list of those expenses, but they're healthcare, most of them healthcare related, childcare related, those kinds of things. It's intended to be an additional benefit for county employees. And be happy to answer any other questions you might have about this. This would go into effect again beginning November 1, and it would be done during open enrollment this year in August in association with other healthcare benefits. Happy to address any questions that you might have.
Judge, I'd just like to make a point. I've been involved in 2 different companies now that have instituted an HSA for the first time. And both times, employees tend to be reluctant to get on the HSA because it looks like they're contributing money to that HSA that is now coming out of their pockets, and they are, and they're not going to receive a benefit, a tangible benefit for that. However, when you do the math, the taxes that every employee has to pay in at the end of the year, if you've taken something out of your paycheck and that is now pre-tax and contribute to that HSA, and you're still spending that HSA money on your co-pays, on your Advil, on anything that you need to get at CVS, Walgreens, for your kids' stuff that they might need, that's health related, that comes out of your taxable income, and you save the taxes that you would have otherwise had to pay. And unless you just aren't paying any taxes to begin with, which is a possibility, but unlikely, I think, for most of our employees, or you don't change tax brackets, you may not save as much if you don't get out of one bracket into another, if you can afford to do that. But I would highly suggest that everybody look at the benefit, and as Laura and our HR department lets people know about this, that we in some way, shape, or form try to show an employee that if they have this much salary, they pay this much taxes currently. If they contribute XYZ number of dollars to that HSA, it will affect them in this way positively at the end of the year on those taxes, so that we can show our employees the benefit of this. Because I don't want any employee to not take action on this thinking they're not getting a benefit when they really could have. And sometimes it's difficult to see that if you don't just put it out and show folks details of how that's going to work. And I would hate for any of our employees not to take advantage of this, because it is a good program. It's good for almost every employee, if not every employee, to participate in these programs. And what usually happens is the first year, 2, 3, 5 years, employees don't participate because they don't see the value. And then 5 years later, they get on it and go, wow, I wish I'd have done this 5 years ago. And they lost that benefit for years. And I don't want to see that happen to our employees. This is a good product, good program. And I'd like to just reassert that we need to make every effort possible to show our employees what this truly does to their paycheck.
Thank you, Commissioner. Any other questions? I see Laura's in the room now too, so if there's any specific questions, I will direct them to her.
I looked at the plan after we left, and I believe on that one, they did not have the rollover at the end of the year, or that up to us if we want to add that feature to it.
There is an option to add a rollover.
Laura, you can.
Oh, I apologize. I'm sorry. Thank you, sir. Yes, there is an option to add a rollover, and there's I apologize for not having that there. Not ready for this, I apologize. Okay.
I just remember seeing the check when I got home.
I don't believe it was in the presentation, but we had talked about it. Jeff Wooster from Emeritus. Actually,
Was there a cost for the rollover?
I don't believe there was a cost. It was just an option that was available to us.
And normally if you have that rollover, that means you don't have to pay it all that year. Normally it's like 500 left.
I guess they would set that amount, the rollover amount.
That's what it said.
They would say,
It's a $500 rollover provision. It says for employer groups that elect the rollover option, participants in the FSA will be allowed to roll over up to $500 in unused healthcare FSA funds for the use of the following plan year. It applies only to healthcare FSA unused funds. An employer can select the rollover option. However, they are not allowed to offer the 2.5-month extension. Employers do not have to adopt this rule. The provision does not affect the ability to elect the maximum amount the following year. Even if the funds are rolled over from the previous plan year, the participant can still elect up to the maximum FSA contribution allowed under that plan. And they gave us an instance. If a participant rolls over $500 from the 2018 plan year, and his or her employer allows them to make a $2,700 FSA contribution over the 2019 plan year, the participant can still elect the full $2,700 and roll over $500 from the prior year. And the rollover only applies to health FSA unused funds. Employers do not have to adopt this rule, but they have that opportunity.
So does the rollover, is it in addition to the $2,700 or is it within the 27?
You can still get the full 27, still roll the other 5.
Does the employee every year make the determination, I guess, whether to participate? Let's say you get in the program and then the next year you don't want to, or I don't want to put it in here, I'm gonna let it roll over. I mean, so they have the I guess,
Opportunity to make that change.
responsibility, I guess. So you can every year ask if nothing says it's,
Sure.
they're gonna go do it again, is that right?
I'm not sure on if they have to sign up every year, but I know they have that option. They can change it, but we'll,
Plans I've been involved in the past, you have to make an election every year. And you,
And if they don't make an election, you just do away with it.
then they're out.
I think we need to make that clear.
okay, yes, sir.
If you make an election every year and this one, but you wanted to,
Again, historically, there's a form and it's, I elect to participate, I do not elect to participate. If you elect to participate, then here's the amount, you're going to designate pre-tax and go forward. But I think the carrier or the third-party administrator requires that.
And I'm pretty sure it's going to be set up the same way we do the health and dental insurance. I mean, if you don't sign up for it, then basically it's going to, they'll drop off.
Some kind of presentation explaining all of this.
Open it, open enrollment.
We will get all that together, have samples, and once we have this approved, then I'll work.
So there's no cost for the rollover provision?
From what I'm understanding, there's not.
I'm not sure why we wouldn't.
it'd be a good time.
Okay. All right. Thank you.
Thank you. Thank you, sir.
So the motion would include authorization to execute the 36-month agreement with Ameriflex to include the rollover option. Any other questions? If not, I'll entertain a motion on item 8. Motion made by Commissioner Schuman, second by Commissioner Whitson. Any further discussion or questions? If not, all in favor say aye. All opposed, same sign. Motion carries. Thank you, Court. Item 9 is consider making a determination as to whether circumstances are present in all or part of the unincorporated area of Bell County that create a public safety hazard that would be exacerbated by outdoor burning and issuing an order restricting outdoor burning, otherwise known as the burn ban. Fire Marshal and I spoke earlier today. I'll let him come forward and give you his recommendations as of today, but I think what he was that he's not recommending burn ban at this time. I don't know if you, I appreciate you sending the links on the, I can never recall what that's called, but the fire, no, fuel, I'll find it here in a second. 10-hour fuel moisture percentile less than or equal to 25%. If you haven't seen it, the Fire Marshal sent a link or an email with some links associated with that. And there's a map on those links. You got to click a couple of times to get to it, but you get to the link and it shows you what the current fuel moisture map looks like in colors instead of numbers. It's just kind of blue, yellow, green, red, whatever it is. At any rate, Recommendations today on the burn ban?
Not today, sir.
Not today. All right. Any questions? Thanks, sir. No action on item 9. And again, as is our custom during this time of the year, I'll keep that item on every agenda, so it gives the fire marshal an opportunity to come forward and make a recommendation to you. All right, item 10 is discuss and consider action on the Bell County Local Disaster Declaration dated March 18th, 2020, and any associated directives that may have been issued by the county judge, and any federal or state declarations or orders associated with such. Court, in case you missed it, last week was an eventful week associated with orders and directives that have come out. It began on Monday with the governor holding a press conference stating that COVID is spreading at an unacceptable rate in Texas. The governor had a lot of charts and so forth behind him at the press conference, but they were associated with hospitalizations, daily new cases, and the positivity rate across the state. All of those charts indicated flattening until Memorial Day, and then the spikes were depicted in all 3 charts. I won't go through all the numbers that I went through at the press conference, but on Wednesday, this past week, I issued directive number 7, which required businesses to ask that patrons of those businesses wear face coverings while on the premises. There are some exceptions associated with that. They're listed in the directive. There was some signage that has been pushed out also associated with that directive. My intent in issuing that directive was to try and forestall or mitigate some more intrusive directives that might come from the state, as opposed to those that would be issued and hopefully managed locally. 36 hours, well, less than 36 hours after my press conference on Thursday, on Friday, or on June 25th, on June 25th, the governor issued another executive order. That order indicated that all businesses were required to go to 50% occupancy, so he began some closure orders associated with businesses. Again, there were some exceptions associated with that order, and there were also other businesses that were required to close, those being bars, some outdoor activity areas and things like that. That order also lowered the threshold for local approval of outdoor gatherings from 500 to 100 per the governor's order. That outdoor gathering measure required the mayor of an incorporated city where a gathering is occurring of more than 100 to get approval from the mayor, and if it's in the unincorporated areas, then from the county. So that was sort of the backdrop from last week in terms of the directive and the order. Be happy to go into any more detail that you might want associated with the directive. Again, my intent in issuing the order was, and the order is for a period of 2 weeks beginning today, or at midnight this morning, 12:01 a.m. this morning to July 13th. My intent is to monitor and have at least every other day conversations with our 3 largest healthcare providers in the county, Baylor, Scott & White, Advent, and Seton, monitoring their hospitalization capacity. At the time on Wednesday last week when I issued the directive, I had conversations with all 3 of them. The largest one, by far, Baylor, Scott & White, had indicated some concerns about hospital capacity in Bell County, which was one of the reasons that I issued the directive. I think those conversations need to continue this week and hopefully early next week. And again, based on all 3 of the healthcare providers recommending the face coverings in place, and including the public health district director. Again, that was some of the background for issuing the directive. As with every directive, the 6 previous directives that were issued, all of these directives, I think, are subject to the will of the Commissioners Court. And so if the Commissioners Court determines or believes that directive needs to be modified or rescinded, I think it's certainly within the authority of the Commissioners Court to do so. And that's why I have this item on the agenda, have had it on the agenda every week since March 18th. Happy to entertain any questions or any comments that you might have.
Couple questions on the governor's new directive. That's 50% in restaurants, not all businesses.
Well, the initial, let me find,
All businesses.
yeah.
All businesses. So
I'll,
HEB 50% only?
I'll read the, unless there's an exception, And the governor had carved out exceptions. And hang on a second, let me get it. But I believe the first order, the language, every business establishment in Texas shall operate at no more than 50% of the total listed occupancy of the establishment, provided, however, that, and then there's a list of exceptions. And exception number 1 on that is any service listed by the U.S. Department of Homeland Security, Cybersecurity, Infrastructure Security Agency, which does include grocery stores and food service places, things like that. So that's listed as an exception. But the prime directive that was sent out was every business establishment. So you have to look at that and then look for an exception down the list. And that's consistent with the way I think most of the governor's orders have been since probably about GA 15 or 16 or somewhere in there.
So many gatherings now over 100, that's going to be the local authorities enforces that.
Yeah.
I mean, well, first you got to go to the mayor, and if the mayor was to approve it, then I guess he or she would
I have it.
comment on that.
Yeah, I have, and I'll just read you again, this is from the governor's order, GA 28. For any outdoor gathering in excess of 100 people, other than those set forth in paragraphs 1, 2, or 4, I won't go back over those right now, the gathering is prohibited unless the mayor of a city in which the gathering is held or the county judge, in the case of a gathering in an unincorporated area, approves of the gathering, and such approval can be made subject to the certain conditions and restrictions not inconsistent with this order.
Okay.
And the mayor, I'll add this too. I did visit with all, or not all, but with the mayors of our 4 largest cities on Friday afternoon after this directive came out. And there is an intent on the part of the mayors and myself to try to establish some protocols or procedures for considering approval or disapproval of these gatherings on a basis that is consistent across the cities and across the county. We're working on that. I hope within the next day or 2 we have something in place that, and of course it's up to each city. Each city can determine how they're going to do that, but there was a consensus to try to be as consistent as we could. That would save confusion on the part of the residents if we were.
And the other thing I have is the mask overnight. You know, personally, I think something needs to get done, and that's my personal. But I do have a little bit of issue with, say that you shall enforce it at your business. I would like to think strongly encourage might be a better way to do that. Obviously, if you did that, there would be no enforcement piece to that. I see a little bit of enforcement potential. And we're requiring the businesses to do that enforcement. And if someone comes in your establishment, doesn't have a mask, and you ask them to put a mask on, you've enforced that directive. If they just won't, I get it, they could say that I can't wear a mask, it bothers me, it makes me ill. But there are those that, I mean, at some point, I guess it would have to call a law agency, and I can see that being a little bit cumbersome, and I would hope the business owner wouldn't think that they would have to drag that person out of the business and escort them to the curb. That could potentially cause issue too. I believe that even if it was strongly encouraged, given the fact that we've already seen what the governor is doing and will continue to do if that spike goes up, and I think he was even, he talked a little bit more about that again. I think businesses would still do it. I think it's necessary, but I think that it needs to be their choice, and their choice is to do it or potentially let the governor shut them down again. I would do it, you know, at my business, and anyway, I would just like the court to look at, or least visit about, strongly encourage versus shall. We didn't have any collective conversation. We didn't have the agenda item to talk about it prior to now. So I thought it might be a good idea to visit about there and just get the court's ideas on that, if any, may not be any.
I don't disagree. The governor is the one that has the enforcement authority, because like Commissioner Snyder said, if you don't participate, then the inevitable enforcement is that you go from 50% to 0. You don't have to have a law enforcement person come in and take somebody out for that to happen. Secondly, all of the directives and all of the orders are predicated on the fact that you maintain 6 foot of separation. And just like all of us sitting here, we meet that predicate. Most all of the people sitting in the audience meet that predicate. So the masks help in many situations, but it's not an end all. It's not something that's going to usurp any of your ability to operate in just a normal fashion if you're able to maintain that 6 foot distancing.
I did, Commissioner, watch a deal this weekend. 2 doctors actually performed an experiment as far as mask, no mask, speaking, coughing, sneezing, and those types of things. And their masks do mitigate the spread. It doesn't alleviate it. There's still moisture that gets, out from the mask, obviously, and we've all talked about that. But I intend to do my part, but that's my choice. Anyway, that was.
I had a lot of experience from different businesses this weekend, and they welcome the mask. They was telling their customers about it, but again, like the information that we put out also, that if there was some medical reason, they could decline wearing the mask, and that hopefully that business was amenable to that and wouldn't want to force it.
I did see your email.
Yeah, and the signage that the signage I've proposed, business not required to follow the signage, but and the signage is also intended to comply with the health and safety policy that the directive required. So there's no need to create anything differently, but the first statement under there says, if wearing a face covering poses a greater mental or physical danger to you than not wearing one, we understand. You're welcome to come in with no face covering. That exception was already built into the directive, just like continuing to maintain 6 foot social distancing. That is still the best thing to do. In every statement that the governor has made, he lists 3 things that everybody should do. Wash your hands, maintain social distancing, and wear a mask, in every order, in every statement that the governor's issued. And again, my reliance was on Baylor Scott & White, Advent, and Seton, and our public health district. And all of them have consistently recommended face coverings, all of them. Next press conference that I have, I intend to have all representatives from all 3 of those facilities here to maintain and assert that very statement. I recognize that this is somewhat intrusive on our businesses, but it's far less intrusive than closing the business. And that's, from my standpoint, that's really, there's 2 intents. One of them is to do everything we can at the local level to prevent more intrusive measures coming down and being handed down to us by the state. I'd much rather manage this as best we can locally, as opposed to letting the state manage it on a statewide perspective. And this is, I think, one small measure that can be taken to do that. And then the second one is, again, on reliance of our healthcare authorities, our local healthcare authorities, that masks do in fact mitigate the spread. That's the 2 bases for the directive that was issued. But again, I certainly believe that this is subject to the Commissioner's Court review and modification if you choose to do so. and I will certainly follow that.
You did what you needed to do, Judge, and well within your authority, and I appreciate that. But it is the court's decision to ratify that by law and not necessarily even to disagree with what you've done, but just maybe after we've had a little time to digest it and see and think and really, because a lot of this you had to do on your own and you had to do in a rush. And I think you've done a very good job in doing that. But personally, I believe that a lot of people just lost sight of washing their hands and distancing and wearing masks and doing all these things we've been saying for months now, because our attention got diverted to other things. And the state started opening everything up, and I think myself, as well as most of the folks that I've talked to, kind of fell into a little bit of complacency and said, well, the governor's opening things up, and, you know, we got other things to deal with, to talk about, and just kind of put all this code in the back of their minds and thought it was kind of gone away. We saw that in a lot of the college students, you know, out on the beach on Memorial Day weekend. The governor opened up right before Memorial Day weekend. They said, hey, let's kind of loosen this up and let's go party, was the message a lot of people got, particularly our younger generations. And then we see this huge spike in our younger generation. You know, under 30 had the largest spike in Texas that we've had since this whole thing started. So recognizing that we've had a spike, recognizing that we only want to be responsible, recognizing that even the governor himself didn't mandate a mask, just strongly recommended a mask, and recognizing that anybody that wants to can walk into a business right now and say, oh, I've got a medical condition and I have to wear a mask anyway. That's made it very difficult on businesses to decide how to enforce it, how to get through all the rules, how to pay attention to all this, and is it right, is it wrong, whereas now, is my business going to be, if somebody comes in and says they have a medical problem, I don't make them wear a mask, and they sit down, and everybody else is wearing masks, and they're looking at me as a business owner going, how come you're not doing anything with that guy? And I have to try to explain this and mitigate all this. It puts the business owners in a pretty precarious situation. And a lot of this, to Bill's point, we talked about earlier last week, is just free market economy. If I'm a business and I want to enforce masks, and anybody that wants to come to my business knows I'm going to enforce masks and they feel safer there, they can come. They don't want to wear a mask, they don't have to come to my business. If I'm a business that doesn't want to enforce masks and I'm a place people can come without masks, then maybe more people come to my business, and I'm taking on additional risk. But other people may see that and say, well, I'm never going to go to that business again. I think every business owner has to decide what they need to do. With your mandate, it says every one of them is going to have to do this, and the ones that are going to try really hard to do it are still going to have problems enforcing it. Still wonder if they have to call the police on somebody. Still wonder if they're going to get fined if they don't enforce it right. And so I don't have a problem with encouraging masks to be worn. I'm a volunteer fireman. We go out on calls, we wear our masks. I know better than to not wear a mask in order to protect my family and protect somebody that's ill if we're going to take care of them on EMS call. So I agree with Russell's statement that while I believe masks are important, while I'm going to wear my mask and try to protect others, if I can't distance 6 feet or better, or if I go on a fire call, I'm going to be wearing a mask. I think it's burdensome and confusing to business owners when we mandate the business to have to be the police on this deal. And then if we go to enforcing that, our law enforcement going out trying to decide who to give a ticket to or not, and I sure don't want to see us get in a position where we have to give somebody a ticket that's being belligerent about it and just refuses, and then that end up being an ADA violation, or that end up being a governor pardoning that and putting our law enforcement agencies into positions that I just don't feel like they need to be in. I would strongly suggest we remove the shall language and highly recommend or remove the fine.
If you said strongly encourage it, obviously you would have to remove the fine. You wouldn't want to.
That's true.
I think that goes hand in hand.
Judge, are there provisions in the penal code if you have somebody that comes into a business that is obviously ill, refuses to wear a mask, and so that basically they're coming in with the intent to possibly infect people, then is there in the penal code, is there a fine that's applicable or jail time?
Maybe a question for county attorney or someone else. I don't know that there is. There may be. I don't know. I don't know the answer to that.
I mean, there still may be some applicable fines or penalties.
I mean, businesses still have, not still, but they have always had the ability to remove patrons from their premises for a variety of reasons. And that hasn't changed. This directive didn't modify or alter those rights in any way. So, you know, the signs that you've seen on doors before about no shirt, no shoes, no service kind of thing. Businesses have always had the opportunity to do that. And ultimately, I think it comes down to if the business owner or manager asks someone to leave the premises. That's typically the request that's made. And if they don't do that, then they can be charged with criminal trespass.
Well, I know, but in the past, a business owner wouldn't necessarily look to somebody who walks in the door coughing as a potential threat to their business.
True.
Okay. This certainly is a potential threat to their business and their customers. And so with all of the governor's orders, is there?
Yeah, I don't know if just, again, I'd defer to legal folks on that. I don't know the answer to your question. The only other item that I didn't mention earlier is in terms of folks that I consulted. I did consult with the area mayors before the directive was issued. And as y'all know, the mayors have the authority to issue directives that are in orders within the corporate limits of those cities. Consultations I had with them, they preferred to have a countywide directive rather than having potentially conflicting directives issued across Bell County. But I did consult with that. I failed to mention that earlier, that in addition to the health authorities, I also consulted with the mayors.
Would, to your point, Commissioner, if it was strongly encouraged, or, and you had that on your business, you had that sign on your business, if you come to my business, you're going to wear masks, you could still enforce it. And you could still enforce that with an officer. I've got a guy coming in, or a guy or gal coming in my business, and have no shoes and no shirt or whatever it might be, or no mask, and you still could get that person removed. I mean, you can still enforce it from a business standpoint, I would think. You know, it's like being disruptive or being whatever it might be, but anyway, that's just a thought.
Was that a motion?
I would say it's a motion, just to do the strongly encourage. Obviously the fines would go away, and let's look at it, and obviously we have another opportunity on the next agenda to even make it more stringent if we had to, so.
Okay. Motion by Commissioner Snyder to remove the mandatory language in the directive and replace that with strongly encourage, and also remove the penalty and fine provision.
Second.
Seconded by Commissioner Whitson.
I have a question.
Yes, sir.
Never mind. I withdraw mine.
Okay.
So I'll remember it later.
Should we pause a little while?
Can we call that a senior moment?
He is a senior commissioner.
All right. Very good. All right. Motion by Commissioner Snyder, seconded by Commissioner Whitson. Any further discussion, questions, comments?
I've seen 3 versions of the official mask sign.
Well, in the new directive, of course, the directive didn't, I don't think there was anything in there that made reference to a specific signage or template. This was provided as an FYI.
Well, and I've seen 3 of those. Okay, there was the original one that actually went up with the directive that made no placations to people that walked in without a mask. Okay. The second one said, you know, how can we help you? We understand you have a mental problem. but come on in, how can we help you? And then the third one is the one that's on the courthouse doors this morning, which is a little different verbiage than the first two. And so is there an official sign, or are people just encouraged to put a sign up that says, please wear a mask?
You know, my answer to that would be after, if the court votes to insert strongly encourage, remove penalty provisions, there's no requirement for a sign at all. And so businesses can free will. They can do as they choose to do.
I'd also say that with this, I would still, I'm okay with having that on the courthouse door. I'm okay wearing a mask in here. I'm not saying remove all that. I think that what I heard and what I've said, I believe we need to do something. And if the courthouse is, I mean, I think we should continue to leave it here and abide by that, because I think it makes some difference.
And be the example.
Be the example.
Well, a couple of changes I would make to this would be, one is welcome face coverings requested, not required, because if it's strongly encouraged, it's not required. That would be my thought anyway, make it requested. And then I would also remove the Bell County Public Health District logo from this, because their recommendation is to do it. And I would just put our logo on there.
The recommendation is also wear masks.
It is, yeah.
Even if it's not mandated, they would still recommend.
Well,
wear
the
masks.
business can require it still,
The business can.
but you're saying the court can't if we say,
Well, I guess I'm asking for clarification too. You want to require it at the courthouse as opposed to be requested at the courthouse?
Does the OCA guidelines not apply to this courthouse?
No, because there's no judicial function in this courthouse, at least not on a regular basis. The OCA guidelines apply to only judicial court buildings and facilities. And this is a legislative chamber. But if you want to leave required on there, you can do that. I think the commissioner's court could order it for this building, yes.
I would say leave it for this building as far as required, because I think all of us are okay with that. It's just, if you want to come into my business or my world, this is what you have to do. If I have a visitor come see me, I would, or my own business, I'll still have the exact same thing I'll have required.
Okay. Any further discussion or questions?
Could you restate the motion, please?
I think the motion was to amend Directive 7 to remove mandatory language and remove the penalty provision. And I will.
Strongly encourage something that,
Right. I'll use.
I'm not sure which word.
Well, in the general public section of it, again, outside of business premises, it says it is strongly recommended. So I was going to use the same language in the top part. And again, assuming that's the court's pleasure, we'll try to push that out this afternoon. All right, any further questions or discussion? If not, all in favor say aye.
Aye.
All opposed, same sign. Motion carries. Thank you, court. All right, that's all of the agenda.